The emergency manager law is a democratic response to the democratic failings of some unit of government or school district. No emergency manager would be sent in if the elected officials at the municipality or school district had not fouled their own nest, so to speak. Cities are not sovereigns. They do not give the state its power. The state gives local units of government their respective powers, and as such have responsibility for helping solve financial problems that might lead, in other circumstances, to a bankruptcy. The review process is actually so detailed, and there are so many hurdles or triggers that need to be pulled before the governor actually sends in an emergency manager. It's a wonder that any city or school district actually has an emergency manager. They can sell assets, but I'm not sure how prized many of them are. After all, many of them are huge drains on local budgets. The fact of the matter is, tax hikes are an option for emergency managers. They can impose them. And that, however, is actually designed to close deficits, not to exacerbate them. They can lay off just about whomever they like, especially under the emergency manager law we're under now, Public Act 4. They have the ability to tear up previously struck collective bargaining agreements, and that's one of the reasons you see such strenuous opposition to this particular law. Under PA 72, you hardly heard a peep from the unions because it was easy for them to dig in their heels and make few, if any, changes. Public Act 4 grants emergency managers the opportunity to set aside a union contract and contract out for services that had not been considered in the past. Pontiac, for instance, has contracted out its fire department to a local unit of government, so it was intergovernmental contracting. No doubt some valuable employees were lost in the process, but the overall process is more efficient, and you're getting at least the same level of services you did under the city provision of fire services. There's no reason that privatization can't be a win-win for the vast majority of residents and employees in the city of Pontiac, or in the future perhaps Detroit, or any other unit of government that comes under emergency manager management and under Public Act 4. One of the reasons is they've appointed a manager with more powers than they actually have, because the manager is granted up front certain powers. If the state of Michigan wanted to set aside the UAW 6000 collective bargaining agreement that they had struck, it would require an act of the full legislature, which might complicate matters. Changes were made under PA 72, but they took longer and were not as bold and did not save as much money for the city. Public Act 4 saves local pensions. I don't think people realize that an emergency manager does not have the right to change the pensions being received by retired city or other local unit of government worker. A bankruptcy judge, however, does. He or she can give real haircuts to pensioners, whereas an emergency manager can't.